We have a number of questions here today, which is amazing. It looks like right now, I'm just doing a quick little count here. It looks like we have about 36 questions. So I'm going to just get right into the questions. Question number 1 is from a board member. Several new 2024 laws override community's documents. Could you provide recommendations for notifying owners of such laws? Are there alternatives in lieu of amending documents which incur legal expense and require 67% approval? For example, the interior modifications for condominiums, House Bill 2141, overrides a CC&R article which requires carpeting in certain areas of second floor units. So really great question. So I think what I would do is, we have a wide variety of laws this year, right? And I think what your association needs to do is take a look at which laws you think will most impact your community. And I think I would talk about them at a board meeting. You might even want to write a newsletter article about them in your newsletter and, talk about the implication of the new law and what does this mean for our community. And maybe you want to get your legal counsel involved to help you write that article. You may also want to talk with your legal counsel about, do we need to make amendments to our CC&Rs to make our CC&Rs consistent with what state law says? Okay, next question from a board member. Can a board member conduct meetings in their private residence? So short answer would be yes. I have seen that. Many boards, have their board meetings in public places. Some of them have them in private, maybe in their clubhouse or maybe at the pool or something, private areas, but they're not private residence. But I also see some board members opening up their home to have it at a private residence. It's probably not best to do it that way because sometimes meetings can get a little feisty. It works for some associations, but it doesn't work for others. Question number 3. I want to know if there is an Arizona law that requires an HOA to have an online bulletin board where both HOA and members can post info and responses to postings. Our HOA uses the management company's bulletin board, but doesn't have capability for members to post responses to any HOA postings. Is there a law? There are some members in the community who are saying there is a requirement for this. What they told me was House Bill 2158 did this. Go back and look at which one is House Bill 2158. Maybe my office can pull that up for me because I think we removed the numbers now. I'm not aware of any law that, says that you have to have an online bulletin board where there can be open dialogue between the HOA and members. I think maybe what you're asking about is, is the posting of the agenda, is the posting of the agenda something that requires us to, have this online bulletin board and advance the meeting? I don't think so. But I'll circle back on this question at the end. My office is going to pull up House Bill 2158 for me. And I'll go back at the end and we'll answer this question again. Okay, next question from a board member. Does an HOA board have a fiduciary obligation to pass a balanced annual operating budget? If, for example, in 2024, the board votes to increase operating expenses, but not to increase offsetting assessment increases, and if the year-end budget is in deficit, is the board obligated to follow January 2025 to balance the prior year's deficit with a suitable assessment increase? So great question. I'm getting this question actually twice in the past month. So this is a great question for all of us to talk about. So I really do think you have a fiduciary obligation to act in the best interest of the community, right? And like anything in business, if you're spending more than you have in your wallet, that's not a good thing, right? And that, in my opinion, is considered a breach of fiduciary duty. So there are some times, though, where your board has no control over this. So let's give 2 examples. So if you're setting your 2025 budget, you should be setting it to zero out, meaning the amount of income should, equal the amount of your expenses. Okay. So just so we're clear on that, like you shouldn't, you don't want to set yourself up for failure on that. In terms of if you're in the middle of 2024 and, maybe you had some expenses that are getting you off budget, and this happens all the time. Like maybe you got involved in a lawsuit, or your electric bills are really high, or your water bills are really high, and they're way over budget and you're having trouble balancing your budget because you're way over budget. I mean, that does happen. It happens probably in every association at some point during the year. In that case, you have to look at, can we skimp on something else? Like, can we not do something just to balance that budget in 2024? Like, maybe we were planning on putting in new tennis nets at the tennis courts. Now we're not going to be able to do that this year because, the water bill was so much higher. I mean, that type of discussion's happening in associations all the time. Occasionally, we'll see an association that's way over budget, and they'll say, can we borrow from the reserve to balance the budget? Talk to your CPA about that. In some cases, you do that, but then you have to pay it back. So I hope that answers your question. I mean, there's no perfect answer on this, but you should be trying to balance your budget. That's something that should be analyzed every month, and definitely when you're planning it for 2025. You want to set yourself up for success by balancing the budget. Okay, next question. What happens to an HOA and its homes when the HOA goes, meaning it can't afford its bills? I think what you're meaning is like, what happens if you go into a receivership, right? Or maybe the HOA just dissolves or something because they can't afford their bills. I mean, it's not a good situation, and it's not something that actually really happens very often because you can't just let the association go. There's an obligation of the board to maintain the common areas. The city's not going to want the property back. If you try to dissolve it, the city very likely is not going to accept the common areas back because it's pursuant to the contract, the association, it has to maintain the common areas. So what happens to an HOA? It doesn't happen very often if the HOA, totally evaporates or become defunct. As a matter of fact, I can't think of one time in 25 years where I've seen that. I have seen associations have to go into a receivership, and it's sad when that happens, and it's very expensive. But the receiver typically will get things back on track. I think I've only seen that 2 or 3 times in a quarter of a century, so that doesn't happen very often. But usually what happens is people step up to help. The helpers come out and they, find a way to get things back on track. Next question, number 6. A growing group of owners are concerned about the fact that the number of rental properties has been gradually increasing. Currently, rentals are just over a third of the units. Would it be wise to redo our documents? And what would that look like legally and financially? We have a great cheat sheet on this topic called Amending CC&Rs and Implementing Rental Restrictions. I would recommend that you take a look at that. You can find that on our website at mulcahylawfirm.com. Doing CC&R amendments, in this post-Callaway time. So Callaway was a case that was decided by the Supreme Court of Arizona several years ago. Makes it a little more difficult for us to amend documents, if the amendments were not foreseeable and they aren't considered reasonable. I think what I would recommend is for you to reach out to our firm. We can take a look at your documents, figure out whether or not you have the votes to implement a rental restriction, and a pivot if you don't, because it sounds like you already have a third of the units. I don't know how much it takes to amend your CC&Rs. Maybe we come up with something that's kind of creative, like we grandfather all existing owners and make the, no renting apply only to new owners. Check out our cheat sheet. We give you a bunch of different suggestions on how to do that, and reach out to our firm so that we can help you with that. Next question, number 7. Can the due date for ballots being returned be 2 days after the special meeting is called? Special meeting is called for September 24th, and the ballots are not due until September 26th. That's unusual. So you're having your meeting and the ballots aren't due until later. I mean, I'd have to see the context of it, because is this the type of a vote where, I could see how this could be coming down. Like, I could see that maybe you're going to talk about the issue as a community at the meeting, and then, they have to have their ballots back 2 days later. Is this the type of thing that requires a vote, in conjunction with a meeting? If it is, then having it due 2 days later may not work. So I don't know enough about this. Sometimes you don't need a meeting with membership for a vote, and I don't know what the special meeting vote is about, so it's hard for me to answer it, but it could be potentially okay, but I'm leaning more towards no, you really should be doing it the same day as the meeting. Now, if it's a CC&R amendment, I mean, you could extend that out past the meeting because most of the time you don't have to have a meeting. So I don't know what the vote's about, so it's hard for me to comment, but it could be okay in certain circumstances. Okay, next question, number 8. If we have a security camera policy and post signs to notify residents they are being recorded, is there any reason we cannot have security cameras monitor the common area pool and pool deck? I don't think so. I think that this should be fine. Run the policy and the signage by your legal counsel to make sure that, they are okay with the language. Next question, number 9. Where does Sun City West get authority to regulate? For instance, if you can divide your house into 2 different rentals, no HOA. I'm familiar with Sun City West. I've been out there many, many times to teach classes, and I represent a number of the associations. At one point, I was legal counsel on a certain issue out at Sun City West. I would say short answer would be they get authority to regulate based upon their recorded documents that apply to the lots or units. I don't know what you mean by if you can divide your house into 2 different rentals and no HOA. I don't know enough about that to even comment about that. That sounds very unusual and it doesn't sound right. So I'm not going to comment on that. I am aware that there is a large master planned association out there and they do have documents. Question 10, our board meetings go on for too long. I think implementing a time limit for comments and questions would make a huge difference. Do you have experience doing this without making people feeling like their questions were not answered? So we have a great cheat sheet on community association board meetings that I would really recommend that you take a look at. We also have videos on our website called How to Have a Board Meeting in an Hour or Less. So 100% you should be implementing time limitations if your meetings are over an hour. Just really the nice way to do it is to have the president say at the beginning of the meeting, hey, our meetings are going too long, and so we're going to try something new this month. If any owner wants to comment, they need to comment during the homeowner forum at the beginning of the meeting. Each owner gets 1 or 2 minutes, whatever you say, to comment. And then when we open the board meeting, it's only the board talking. The only time an owner can make a comment is before the board takes formal action on something. And at that time, you get 30 seconds to make a comment. And just be really nice and give people a little warning. If they're at 30 seconds, say, okay, it's 30 seconds, you need to just finish it up in the next 10 seconds. Or if, they're at 2 minutes, just say, okay, you're at 1 minute 45, you have 15 seconds, let's tie it up right now. I think people get it. And I think most people like to have a time constraint because it helps them, formulate their feelings on something and give their opinion quickly versus just talking and talking and talking with no end in sight. Check out our cheat sheet. We have some very good suggestions in that cheat sheet on how to have a successful board meeting. I think we may even have another cheat sheet called How to Have a Successful Board Meeting. So you might want to look at that one too. Okay, question number 11 from a board member. CC&Rs state that owners are responsible for damage and repairs to the roof. The storm damaged 23 of 44 roofs. I objected to our HOA funds to repair the roofs as this is a contradiction of the above CC&R. Our chairman said in this situation, the insurance company dictates we do. We have a $2,500 deductible. The repairs are over $3,000. The chairman said we will not go through the insurance company and pay all repair. We will not go through the insurance company and pay all repairs out of the HOA funds. I feel this is a misuse of HOA funds because we are not involving the insurance. My question would be, is the board required to follow the CC&Rs, which require or stipulate that homeowners are to pay for repair and replacement? Well, I don't have your CC&Rs, so I don't really know, what they specifically say. And I don't know if you're a condo or a planned community. It's hard for me to comment on this because, one thing that I would look at is, okay, if you have a deductible that's close to what it's going to cost to repair, you may not want to make that insurance claim. That's something a business choice that your board may be making. And I'd have to hear all the facts, but that could be the right business choice. Generally speaking, your board does need to follow the association's CC&Rs, but I don't know what your CC&Rs say on maintenance of these roofs, etc. Okay, question number 12. Should a board member who does not comply with filing the board information on Corporate Transparency Act, should they be removed until they comply? Well, there's really nothing under Arizona law that would allow us to remove them. It's a sticky situation. I would just file what you can based upon what the board members are willing to give and see if it gets rejected or see what happens. If I had to guess, it probably will not get rejected. They might send a follow-up response back, and we'll have to see what that says because this program's so new. But they can't be removed from the board for not complying with the Corporate Transparency Act. That's just not in your documents. It's not consistent with state law. And I'm not really sure I would even suggest that this type of person who doesn't comply should be removed from the board. I mean, I think this problem's going to go away. I don't think in 2026 and beyond, we're going to have to file this Corporate Transparency Act, but I do think we have to file it for this year. Okay, question number 13. We have an election coming up soon and only one candidate to replace 5 board members who are not running for re-election. Our CC&Rs allow for a board of 1 to 9 persons, but obviously it's not feasible just to have one person. What should we do? Okay, you have a lot of people, getting off the board, and you only have one person willing to run. We send out a letter to associations that have this problem. We send it out to the entire membership. We write it, and the board sends it out by email typically. And we just let them know, hey, this is what happens if we don't have a board to run the community. It's possible that a receiver could be appointed to run the affairs of the association, and that's going to cost a lot of money for your community. Whenever we send that letter, typically people volunteer. So you may want to reach out to us and have us help you with that. Question number 14. Our association president believes that by calling a meeting with the majority of the board members a committee meeting, that she does not have to notify the owners of the Zoom information, provide a detailed agenda, or produce minutes. Is this true? No, that is not true. If you have a quorum of the board meeting to discuss association business, even if it's in a committee meeting, it's considered an open board meeting. You need to fully comply with the open meeting law. Question number 15. We are in need of help. We have a board president who is becoming worse. She is a dictator. She now has issued cease and desist letters to a board member and another community member. Neither has done any rule breaking, but they have raised questions and the president is angry. Her and our property manager accept info from no one. Mute people if they don't like what they say. Our community is at odds. What do we do? So it sounds like maybe you're a homeowner in your community and you maybe have a board member who is, a dictator, it sounds like, right? So what are some things you can do? I mean, you can get a petition going to remove the director from office, the board president. That would be a way to get her attention. You can, come to a board meeting, have all of you who are upset about this come to a board meeting and express concerns. You could write a letter expressing concerns. You can run for the board yourself. That's something you definitely can do. You can go to the Arizona Department of Real Estate and file a claim if you feel that the president is not following the documents or exceeding her corporate authority. You file a lawsuit. You can get a lawyer to help you write a letter with your concerns to properly articulate from a legal perspective why the president is engaging in, violating the law or not being reasonable. Lots of different suggestions for you on that. I'm sorry that that's happening. The best thing you can do is get involved, I think. Get on board yourself, try to make positive change. Okay, next question. Arizona Revised Statutes 33-1808 allows associations to limit the display of political signs on a residential property to no more than 9 square feet. This limit is mentioned in our association rules, and flags are treated as signs. A homeowner is using his golf cart as a platform to display 2 large political flags, with each flag measuring 15 square feet, draped over the back and side of the golf cart. The homeowner conspicuously parks the golf cart in the driveway during the day and returns it to the garage at night. The association has received numerous complaints. The homeowner likely will argue his flags are akin to bumper stickers to circumvent the political signage restriction. However, the board believes the statute's signage restriction applies in this case. Using the Arizona Revised Statutes square footage speculation as justification, is the board correct in requiring the homeowner to remove the flags? So short answer would be yes. It appears that, the flags exceed the the signage maximum that's allowable under Arizona law for planned communities. I don't know, we're in August and the presidential election, I'm assuming this is regarding the presidential election, is in November. I just don't know how far you want to take this. I do think this sounds like a pretty egregious situation. I probably, if I were advising you, I would say pick up the phone, call the owner, maybe have your attorney pick up the phone, call the owner, talk about it with them, and just let them know that they're beyond the sign, maximum, and see if we can kind of come to a resolution on this. Maybe a smaller flag that meets the no more than 9 square feet. If the homeowner won't comply, you have to kind of weigh how long is it going to take to, we can send a letter to the owner and then they'll probably have a response. Maybe they hire an attorney and, we're not going to be able to file a lawsuit and get a ruling on this. We're not going to be able to get a ruling with the Arizona Department of Real Estate by, the second week in November, whatever, first Tuesday in November. So, we have to be a little practical here. Hopefully we can make this resolved with a phone call or maybe a demand letter. But these are complicated issues right now. It's a complicated time in our country. And, we're seeing more and more questions on political signs. It's the sign of the times, so to speak, no pun intended. So I think I gave you some good suggestions on how you may want to handle that. Okay, question 17. Why does a president or board members of an HOA have to report BOIR for CTA if a management company handles all the funds? Well, great question. It's because the law says you do. That's the way they set up the law. They're trying to, avert terrorist activities, and they're asking for that information. Is it ridiculous? Absolutely. Is it upsetting? Absolutely. I'm a board member too. I have to give all my information too. But the way I'm kind of looking at it is the government already has all this information on me already. And, it's nothing new. It's new that I'm a board member in my association, but and the information about me is nothing new and I have nothing to hide. I'm obviously not involved in any of the activities that they're trying to, avert. So, okay, next question, 18. Our board just announced they are providing, for a friendly reason, pool keys residents of a nearby HOA during a month or so while their HOA pool is being renovated. There was no notice to residents of a board meeting to make this decision, just an announcement. Do you and your professional advice see liability risks that our HOA residents could be exposed to? Is this a financially and prudent decision by our board? Honestly, I wouldn't be in favor of that. I would have to hear more in terms of the justification on this, but I don't like that in terms of, it could cause overuse. And it could take away the amenity from our current residents. What sort of liability do we have if there's accidents? How do we get that pool key back after their pool is, renovated? We have to now rekey our entire community. And there's a lot more problems there than I would say benefits. Question number 19. If the board is having an executive session, is an agenda required to be posted with the meeting notice to the community? So yes, I would recommend best practices would be to provide the agenda. Now remember, several years ago, the law was passed that said that anytime we go into an executive session, we have to state with particularity which sections under the law, executive session law, we're going into executive session to discuss. So you're probably already doing this. So I would recommend that you just post the agenda along with the meeting notice and cite the sections in the statute that you're complying with. Question number 20. Our HOA has a regularly scheduled architectural committee meeting each month. Does the meeting have to be notified each month with an agenda 48 hours in advance, or can it be announced for the whole year with a general agenda? I would recommend, so you do have to give the 48 hours notice, right? Let me go back up and look at that agenda law real quick again. I think there was a caveat that it was only for board meetings. Let me just see. It's only for every board meeting. So I think, if we're going to read that, it's, regular board meetings and executive session meetings. Now, best practices would be, in my opinion, to also give it for the committee meetings. But the way that the law is worded, I don't think you have to do it for the committee meetings. Because it doesn't say board meetings and regularly scheduled committee meetings. But, that being said, I would still consider doing it anyways because it's easy and it just shows transparency. So I would do it. Okay, but let's see another thing here. Okay, so question, you do have to have an agenda though at the meeting. Just so you know, that's something that is for any board meeting or committee meeting. I think that's important. And honestly, for the architectural meetings, I think it's a good idea to have the agenda too and list which properties are, there's a change up with, because if it's a neighbor, they may be interested and you don't want them coming back later and saying, well, I didn't know my neighbor was putting a second story addition on the property. Okay, question number 21. It is assumed that if a board member refuses to provide their personal information as required by the new law, they must resign their position. We're getting a lot of questions on this in the Corporate Transparency Act. So, I mean, you can request that, but I don't think that they have to. So I'm starting to see this more and more. This is like the third or fourth question today on this. So I don't think you can assume that they must resign their position. They don't have. That's not something that's required. I do think on that flip side of that, that it's not that big of a deal to provide it. So I would recommend that everybody who is a board member, should be complying with the Corporate Transparency Act requirements. Now, if they don't want to, of course, they may say, I don't want the hassle, I'm going to quit. That's fine. That's their prerogative. Question 22. What rights does a community have if they have a Greenspace easement with SRP and want to add amenities to that area? Is the community responsible for the property taxes of this, or is SRP? So I'd have to look at your plat map to see exactly how the, green space is set up. So it's hard for me to comment on it, but I'd have to look at your documents. I think that's probably the best thing I should say. And I've really never seen anybody building amenities in green space in 25 years. So, there may be prohibitions on it on the plat map, etc. Next question, 23. Can a management company tell the board that community managers are in place to manage and enforce compliance and violations of the CC&Rs, and that the interference of the board trying to micromanage that process over the community manager is counterproductive and is creating issues for all? Can the community manager tell them to stand down or do that part of the compliance themselves if they won't? To me, that sounds like there's a little dysfunction going on between your board and the management company. I mean, I don't like to hear this. Again, we got to go back to what I said earlier in the presentation, that we're all a team, right? And as part of our relationship as team members, we should be able to work together and communicate together. Now, yes, generally speaking, I would agree that managers, that's their job to manage and enforce compliance. But as a board member myself, I can say that sometimes the manager isn't catching things that I'm seeing. So I do email the manager, hey, take a look at this, or I saw these violations. Here's the pictures. Please go out and take a peek at them. I don't think that's micromanaging. I think that's just being proactive, and I'm doing, what I'm supposed to be doing under my fiduciary responsibilities. Now, that being said, I'm not out patrolling, the neighborhood every night with my camera looking for violations. Big difference. I'd see a violation that's like, okay, yeah, I can't overlook that as a board member. I snap a picture of it and I send it to my manager. Maybe once or twice a month, maybe. Some months I don't even see anything that would be worthy of doing that. So I think there's a balance there. I think maybe you might want to consider having a boot camp with our firm to talk about the issues with your management company, because it sounds like things are going in a dysfunctional direction. Okay, question number 26. I'm just going to do a quick question to see how many. We're getting a lot more questions, 44 questions. So next question. We are a new association in Buckeye. I have been attending your classes. How hard is it to change to your law firm? Oh, that's a good question. It's very easy. So really you just need to have a majority of your board vote to hire your new attorney. And you just sign the agreement, representation agreement, and we're working together. Okay, question 25. If CC&Rs do not allow, do we have to allow? It depends on how it's worded. If it's very clear, like sheds are prohibited, then you should not be allowing sheds. Now, there's some exceptions to that. Like, let's say somebody put a shed in 10 years ago and we didn't do anything about it. We may be prohibited under waiver latches from enforcing it. So we have to look at it on a case-by-case basis. Okay, 26. When a homeowner is cited with a violation within a surveilled area and requests to review the video evidence, is the association obligated to share the video? I would say, if it's a book and record, then you've kept it. Yes, I think it should be provided to the person that's requesting it. 27, if someone is running an Airbnb in our condo community and it's prohibited in the CC&Rs, is there a limit to the fine that can be assessed? So no, just the fine under Arizona law says it has to be reasonable. And I typically say that, you probably want to charge the fine or levy the fine in the same amount of money that the rent is, so that they, I think that's reasonable in light of the fact that they're getting the benefit of maybe $500 a night. Maybe the rent needs, or maybe the fine needs to be in that neighborhood. Question 28. What happens when a committee is formed by the board, however, does not listen to the committee? Or what if they mean to the board? Okay, so what happens? Oh, so maybe the board's not listening to the committee. Okay, so board creates a committee. And then the committee provides information to the board and they don't want to hear it, or they don't want to listen to it, or they don't like what they're being told. I mean, ultimately, that's how things work sometimes, and so the board chartered the committee to do certain things. The committee reported back. The board doesn't have to follow exactly what the committee says. They can just take the information in and make their own decision. I mean, obviously, if the committee, did a good job and they're making good choices, the board really needs to seriously consider what the committee's saying. Next question, 29. Can a master association delegate their enforcement duty to sub-associations? Yes, I see that in documents from time to time. It really should be in the CC&Rs that they're doing that. Question 30. How do we obtain quorum for annual meetings? We did not reach quorum last year, and have already had to reschedule our annual meeting for this year because we didn't have a quorum. So we have a great cheat sheet that covers this topic exactly. It's called Annual Meetings, and some quick suggestions on how to get a quorum. Put something controversial on the agenda and people will come. Like a special assessment or increasing the assessments or change of use of the common areas, something that's people be interested in. Invite a guest speaker, make it a social event with free, cookies and lemonade or whatever. Make it at a time that's convenient for everybody. Give people an opportunity to appear by Zoom if they can't be there in person. I mean, there's all kinds of different suggestions that we put on our cheat sheet that you should take a look at. Okay, what happens? Question 31. When the questions asked are obsessive, how does the board deal with this? I'm laughing just because I see it so often, so I have to give you a little chuckle there. Well, when somebody gets obsessive, that's usually the best time to give the person to your attorney to manage them, because you might be dealing with like mental illness or something, and it's unfair to stick that person on the management company. Our firm is very well equipped to handle those type of situations. We have a lot of obsessive owners that, we have a little plan that we follow with them, get them back on track. And if you provide us with that person's information, we will get them moving in the right direction. Mainly, we're friendly and cordial, but we're firm. Like, if you have questions, this is how you are going to be answering them, how you're going to be sending them to me going forward. And, I set up a method for them to communicate with me that prohibits them from, emailing me 50 times a day. You can send me one email a week with your questions. Recognize that we, are not required under the law to answer every question. We are required to respond to records requests. And I just try to be nice. And usually what I do when I get one of those people is I ask for a phone call and I ask them, what's going on here? What are you so upset about? We try to talk through the issues and try to get them on the same page as the board. Next question, 32. We're planning our budget. Is the Open Meeting Act applicable to board meeting to plan next year's budget and bound to give notice to HOA members? The budget is not a reason for an executive session. That is true. So anytime you have a quorum of the board discussing next year's budget, it should be an open meeting. If you don't want it to be an open meeting, only have less than a quorum meeting. Question 33, can a husband and wife serve on a board as two directors? My team is, we're all laughing because we're all sending notes through, we're all looking at the same questions at the same time, and we say it's our favorite question. So we do get this question often. So generally speaking, yes, unless the bylaws prohibit it. Is it a good idea? No. For various reasons, for various obvious reasons. It gives too much power to one household. It's just not a healthy thing to have, and we do not ever encourage it. Question number 34. What happens when a unanimous consent for board action in lieu of a board meeting fails to get all board members' signatures? Does the subject fail and cannot be brought up again, or what happens? Or does the subject go to a regular or special board meeting for action by the board? So, if it fails, it fails. You can reintroduce it at a board meeting in the future. But I think the bigger question is you really shouldn't even be doing the unanimous consent for board action, because I think those violate the open meeting law. Question number 35. Yep, 45 questions total, so we're getting close to the end. What should be included in meeting minutes? So I have a great cheat sheet on board meetings. On the flip side of it, I says how to take perfectly proper meeting minutes. So take a look at that. The key thing is 30,000-foot view of this is the minutes should reflect what was decided. It shouldn't be a word-for-word diatribe of everything that was discussed. It's big. The decisions that are made at the meeting should be reflected in the minutes. Minutes should be like 1 page, maximum 1.5 pages. Next question, 36. If an AC or landscape request is denied, should the board explain the reason they denied the request? I don't think you're required to explain the reason, but it's a nice thing to do, to have transparency and to make the homeowner feel like they were heard, and to have an explanation why it didn't work and what they might be able to do to make it, do something that would get approved. Next question, 37. How do you balance deferring to the management company, if you have one, versus the board taking the lead in decision-making and strategic planning for the community? Here's some context. Some board members and community managers view the management company as the expert and prefer to defer all decision-making to the management company. I think it's just like a balancing act. So, I would not defer all decision-making to the management company, because that's borderline breaching your fiduciary responsibility to the community. I think the key thing to look at is here, when you're serving on your board, if you have an expertise and you can help the board, let them know, why you have the expertise. Like, hey, I've been a structural engineer for 50 years, and that wall doesn't look like it's being built right. Or like in my case, I'm not the legal counsel for my association because I can't, do that because it would be self-dealing. But I can look at an issue and be like, okay, I feel based upon my expertise that maybe we need to manage this lawsuit a little differently. But I think that's totally fine. You just have to balance it. Is this person really an expert? Are they really helping? You have to have a majority of the board agree, before you can, move forward with, like strategic planning. But I wish more boards were talking about strategic planning. And if somebody has some experience doing that, by all means, I think they should be helping the community. If they don't have experience and they go to a class on it, that's okay. Get some experience and then come back to the board with your suggestions. Okay, next question. What are options for community that is having challenges obtaining community insurance due to their claims history? Coverage that is required by the governing documents as well as by lenders for any potential buyers or sellers in a condo community. So if you can't get insurance, what are our options? Pay a higher deductible, go into the high-risk insurance market. It's really not an option to not have insurance. So if you're in this situation, reach out to our firm. We can definitely help you navigate this. We've helped other associations many times, dig out of an insurance problem where they can't get insurance before. Next question, 39. Our community is a 50-year-old community, and our board is attempting to set up long-term plans, but have a lot of resistance, especially from our older members. I'm laughing because I feel like this is my association. How do you convince those people that it's in their best interest, as well as being best for the overall community and for property values? I think you have to bring in a team of experts to provide the information to the membership. So there's some long-range planning companies that are out there that come up with 5-year, 10-year plans that are amazing. They come in and do a study of your association, including a survey, and that, gives you feedback how many people in the community want the changes, etc. For the older members, you can just provide the evidence to them. Like, here's the realtor's, opinion about property values that would go up if we redid our 4 pools. And here's the 5-year plan from the company that does strategic planning. Ultimately, give them as much information as you can, but recognize that sometimes people are just stuck in their ways and they don't want change, and we're not going to be able to get their vote until they move or until they move on. Okay, next question, 40. A community member is accusing board members via social media of taking kickbacks from vendors. How would you advise to handle this? Ooh. I would have your attorney send a letter to that community member, demanding a retraction, and, reminding them of, what the defamation laws are in Arizona. Question 41, how do we avoid embezzlement? I have a great cheat sheet on this. And I also have a number of classes that I've taught on our website under helpful videos at mulcahylawfirm.com. So we give you a whole bunch of suggestions. So I really encourage you to take a look at that cheat sheet. I have it right on there. Like, here are the things, here's what fraud and embezzlement looks like, and here's what you can do to prevent that. And I think we're sharing that with you here now as well. Question 42, what is required for minutes? Are they obligated to record details of discussions of agenda items, or just note report or discussion took place? Should minutes be more detailed than the agenda? So again, as I said a few minutes ago, the minutes should reflect what was decided by the board. Do we have to record details of discussions? No. I think you do have to report, though, that a discussion took place. You could say, like, we discussed, the board and several community members discussed putting umbrellas at the pool. That's enough. Well, I think you don't want to have the pros and cons of umbrellas at the pool. You don't need that. Should minutes be more detailed than the agenda? Yes. You have to fill in the gaps from the agenda. The agenda is typically just a sentence or a word, new business, old business, whatever. You have to fill it in with anything that was decided. Question number 43. Residents have expressed concern over a resident who seems to have an alcohol problem. He recently damaged community property while driving. Residents are worried he may cause harm to himself or others. What is the HOA's obligation to take action, and what can we do without violating his privacy? Well, I think I would do a police report for sure on the damage to the community property so that the police, are involved. I think that I would have your attorney send him a letter. I don't know if this resident has family members that live there, but it might be something where we reach out in person or by phone to talk to the family members, about the situation. These are always difficult situations. Reach out to our firm. We've had situations like this before, and I think I can give you some good suggestions. Question number 44. What do we do if our property manager altered the minutes of our meeting? Can we rewrite them to reflect what actually happened? So far, we did not accept the minutes. So absolutely, the board makes a decision on what goes in the final minutes and majority rules. Question 45, what are the rules for using reserve funds? We have a great cheat sheet on the topic of reserve funds. We also have videos that I've taught on our website, mulcahylawfirm.com, where those videos are, the main topic is reserve funds, and our cheat sheet is one of our best cheat sheets on reserve funds. You can find both of those on our website at mulcahylawfirm.com. Basically, what are the rules for using reserve funds? You want to talk to your CPA about this, but you should really only use reserve funds for the items that are listed in your actual reserve study. Okay, I'm circling back now to the one question kind of towards the beginning, House Bill 2158. The question was, do we have to have an online bulletin board where both HOAs and members can post responses? So basically what this says, let's see, so this is a law from last year, the House Bill 2158, where it's talking about peaceful assembly. So basically how this works is if a group wants to meet in the common areas of the association, they certainly have the right to do that. The board cannot prohibit it. If the owners that are meeting in the common areas of the association for their peaceful assembly want to publish, or have the board post something about the meeting, the board has to allow that on the bulletin board. So, but this doesn't require, there is no law that says that there has to be a bulletin board where you post info and then the responses to the info that was posted. No, it's just, basically if this group in your community wants to have a meeting, a peaceful assembly meeting, and they want the notice to be put up by the board regarding the peaceful assembly meeting, the board has to allow you to do that. Keeping you posted on our future classes, we have our next live virtual First Friday event, and that is going to be coming up here on Friday, September 6th at 9 a.m. That's going to be our last chance to talk about the new legislation before all these bills go into effect, so make sure you show up for that. We also have class number 9, the ABCs of enforcement for HOAs and condos. We're going to be talking about lawsuits, how to enforce via lawsuit, how to enforce via the attorney, fining, how to enforce using the Arizona Department of Real Estate. And we're going to be teaching that class on enforcing your documents on Tuesday, September 17th at 11 a.m. We also have 2 opportunities in September and October with the city of Scottsdale through their neighborhood college. We're going to be teaching those 2 classes in person versus the online classes that I just talked about. The first one's going to be on Monday, September 16th from 1 to 3 p.m. We're going to be talking about Finances 101 for associations and how to prevent fraud and theft of association funds. We're also going to be talking a little bit about the legislative update, because it'll be 2 days after the new legislation just took effect. And then we're going to be teaching another class for the city of Scottsdale on October 7th from 1 to 3 p.m., again in person, how to work effectively with management companies. Lastly, just we would ask if you wouldn't mind, consider leaving our firm a review on Google and or Yelp. It helps us provide feedback for how we're doing in these classes. If you'd like to see more classes, that's one way that you can really help us, by giving us a review on Google or Yelp. And we're sharing a link in the chat on how to leave a review. We are always happy to get your feedback. We want to teach classes that are informative and that are helpful to all of you so that you have successful associations. And we, of course, always want to improve our service too. So take care, everybody. Have a great rest of August. Happy Labor Day a little bit early. And I look forward to seeing you for First Fridays in September. Take care.